Well, this is a temporary restraining order. We have to go through the process to get a permanent order. But this is the first step. It's a big step. And we look forward to our day in court, which, we hope will be very, very soon.
That was State Representative Dan Calkins talking about a temporary restraining order issued in the case that he brought on behalf of himself, a jewelry store, also around 2,100 other plaintiffs in a Macon County decision handed down yesterday for a temporary restraining order. And the attorney who argued that joins us now, Jerry Stocks, here on WMAY. I'm Greg Bishop, now 744. Jerry, thanks for taking time with us this morning. Talk about the temporary restraining order and some of the arguments that you used in court. Good morning.
Yeah, thank you, Greg. First, I want to make clear, because there's sometimes confusion on a TRO, there are only 4 plaintiffs in our case, but one of the plaintiffs had 2,100 members, and within the scope of the restraining order, the scope of the order includes those members. It's a fine distinction, but they are not plaintiffs.
Gotcha.
They are merely members of a group that's protected.
Gotcha.
And another thing, just to make clear, because sometimes it's such an emotional issue, and at this stage, is that everyone needs to understand that it is only a temporary restraining order. And that's not an adjudication of any constitutional question on its merits. It simply is saying that there's a fair question that the law could be invalid. And in this instance, in our case, a little different than the case that's been to the 5th District, it's that fair question exists on 2 questions: equal protection, and the second one is the proscription against special legislation, both under our Illinois Constitution.
And I want to talk a little bit about the special legislation aspect of this in a moment. But to the issue of those who are impacted by this temporary restraining order versus what you were arguing in court, you were looking for a statewide order from the Macon County judge. That did not come about. What's your understanding behind that decision?
It was a negotiated, unopposed order. The basis for a statewide operation, what would be called void in its entirety in all applications, is a determination that the statute fails facially, meaning we don't need any facts. Just the 4 corners of the statute is unconstitutional on one of the grounds we raise. We persist in that position, but that's called declaratory judgment, and we were only 4 days after service. So we argue the point. I still submit that it is valid. The judge didn't deny it, but for a declaratory judgment at 4 days after service, I did not want to risk procedurally without further issues worked out with the defendants. Premature final adjudication on the merits. But the case law is very clear. Once we have that adjudication on the merits, and if it says the same thing the 5th District said, the statute falls in all application. So that was the objective of the suit, is the objective of the suit, continues to be the objective of the suit as we move forward.
We're talking with Jerry Stocks. He is the attorney who argued on behalf of State Representative Dan Calkins and other plaintiffs in the Macon County case, and that included, again, the 2 charges at least upheld as far as a likelihood to succeed on its merits is the equal protections and also the special legislation. But just so people do know, the docket does show that there's going to be a status hearing March 20th in Macon County. So with a temporary restraining order, for people who don't, they don't have law degrees, I don't have a law degree, what ultimately happens next with this? Does it go to trial? Is it back into the Macon County court where you start, finding all kinds of different evidence and whatnot? How does this work?
It is, in my view, and of course there'll be discussion with the named plaintiffs, that our next step would be moving for the declaratory judgment attacking on its face. which is it was part of our alternative relief that we did not move forward on, but that we filed the motions on already. And we will not wait to March 20 for that. We will, I anticipate, move for that and then be subject to when the court would schedule us for hearing. I do not see that there's any need for any protracted discovery. It will be basically developed and argued on the law and the content of the pleadings. The other side will answer the pleadings. We may amend to add some facts or may not, just as we work through drawing the issues so that they're fully vetted and orders can be entered.
Jerry Stock's with us, again, the attorney who argued in front of the Macon County judge for a temporary restraining order, and that was issued yesterday. This follows the White County restraining order that followed the Effingham County restraining order being upheld by the Fifth Circuit Court of Appeals. And again, the Effingham County original restraining order hit on all the different aspects from, the charge of 3 readings violations, the due process, the single subject rule. Those were not carried through the Effingham County appeal, and that was upheld just on the equal protections. The White County courts also upholding it only for the equal protections. This decision from Macon County yesterday doing the equal protections, but it was also an argument you raised in court called special legislation. What is special legislation, and how does it differ, if it differs, from the idea of equal protections violations?
Equal protection is a predominant subset of special legislation. Special legislation does a couple extra questions and what I think are particularly more accurate challenges on the statutory scheme than equal protection, and it arises from a different constitutional provision, Article 4, Section 13 of the Illinois Constitution. And it specifically invokes the jurisdiction of the court to determine whether the state or public interest could be regulated by a general law as opposed to a special law that creates benefit, privilege, or immunities for some, but not all that are situated similarly. And because the scheme of this legislation creates not only classifications between just everyday able-bodied FOID card holders, it also creates accepted classes and treats some of the accepted classes differently. And we have a real patchwork of classifications from which each subset has different immunities, exposures to criminal sanction, privileges, benefits. Some are utterly prohibited and some are regulated. And special legislation is going to say, if you can pass a general law that is narrowly tailored, that would allow one law to enable everyone to be treated generally the same. For example, if it took training to be the equivalent of a retired police officer, you can't just extend the privilege to the retired police officer and prohibit altogether a pathway for others that are FOID card holders. The examples are, in this scheme, 15, 20 different examples one could illustrate. So it's that framework that we want to attack. And in the real question, the 5th District decided, because we're a Second Amendment right that is the contours of the Second Amendment right are affected by these classifications, is that strict scrutiny would apply. And that's a very difficult test for upholding the legislation. It's not a good test for the governor's side of the equation. And they want to argue that it's only a rational basis should apply. And I think the determination of that question will ultimately say a lot about which way the case goes.
Well, we'll be watching that closely, as well as we watch a bunch of other cases, not just in state court and federal court, but this one being the most recent, where action was taken yesterday in Macon County. It's been less than a month since the gun ban and magazine ban was enacted, and so far 3 different state courts issuing temporary restraining orders, and we'll see where this ultimately goes from here, as we've got that deadline of October 1st to January 1st, the window for when people have to register their grandfathered weapons that the legislature deems assault weapons. So we'll, again, be watching this closely. Jerry Stocks, attorney for the Macon County case brought by State Representative Dan Calkins. Appreciate your time this morning. Be safe out there, and we'll talk again soon, okay?
All righty, thank you.
It is Springfield's Morning News, now 7:54 on WMAY.
It's time to apply.